action by the Crown when they could have been proactive in securing dates.
The judge had decided, unless I am mistaken, that you had until November 3rd to present your 11B application.
That same judge was the judge that ultimately heard the 11B application. And he addressed this in his decision, and he said, essentially, what am I to make of the fact that defense did not file their application according to the 120 days? And he found that that, in effect, was no issue. And again, he is the same judge that said that directive because the Crown was put on notice in July that the application would be brought. And there was no action by the Crown until March 14th, 2023.
May I know why it took so long to file the application? You gave a notice of your intent to bring such a motion in July 2022, and it is only in January 2023 that you filed an actual notice of application.
Counsel for the respondent brought the application at a time that was convenient according to their schedules. There's also, in terms of how approval works for 11B applications, if there's a legal aid plan, there needs to be approvals worked out, and there also needs to be time to actually file the materials. Now, in January 24, 2023, a Form 1 notice of application was filed. It laid out the grounds for the application. That takes time to work out, and essentially my answer is that counsel brought it at a time that was convenient for them, and we recognize that there was the directive that it should have been brought sooner, but it wasn't. But again, the application judge, who was the same judge that provided that directive, did not think that that was an issue at all because the Crown was put on notice. And if the Crown was waiting for the materials to be filed, that was not diligent and proactive. And even when we did...
You would agree that it took too long to file the application. Would you agree to that?
I would agree that it took long. I don't know that it took too long. The notice of application was still filed 7 months before the ultimate trial date.
But in practice, it's not unreasonable to think that one can change their mind if it took that long, if did not respect the delay given by the judge to file the application. It's not unreasonable. Don't you think?
What I think is that it did take long, but again, it was brought 7 months before the notice of application was brought 7 months before the trial dates were set. The current practice direction is that it only needs to be heard 4 months before the trial dates in the Ontario Court of Justice. This was not saying 2 weeks before the trial date we're bringing an application. The Crown was put on notice back in July of 2022 between the first initial dates being offered being above the ceiling and the fact that I myself said in court, we are going to be filing a Section 11B application. And the Crown did nothing. And even if we follow the premise that they were waiting for the materials to be filed, well, that is not accurate either, because once the notice of application was filed in January of 2023, and again, that was a Form 1 notice of application. That's actually all that is required on an application in the Ontario Court of Justice.
It seems to me you have no explanation to put to the court as to why, when the trial judge set the time frame, you blew past it and told nobody anything.
But the Crown also didn't ask. The Crown was put on notice. They didn't ask at a subsequent appearance, what about the 11B application? But again, I think all of this is clouding the analysis because it shouldn't matter if an application was filed.
Well, just a minute. Are you saying that it doesn't matter when a judge sets timelines, that defense doesn't have to follow them?
No, I'm not saying that at all, Justice Obonsowen. What I'm saying is that that particular judge that made that directive was also the same one that ultimately heard the application, and he himself found that it was completely irrelevant
So coming back, I had asked your colleague about what they could expect to see in the application that would inform their decision, and you heard his response. And I'm wondering, how would you answer that question of how it would impact the Crown's actions?
Well, I don't know that what we're advocating for is that we shouldn't be required to file an application at all. Telling the Crown that their delay is an issue should be enough to act, because these applications do not spring into existence. They are time-intensive, labor-intensive. We also need to order transcripts, get prior approval from legal aid, and if we require this burden of an actual application to be filed for the Crown to spring into action, I think that's an inefficient system, and again, delays the need for the Crown to be proactive and actually remedy the issue. Because even if it was brought in 120 days, that would have been several months after delay first became an issue. That is several months of missed opportunities from the Crown to actually do something. And again, when we did do something, the Crown still did not act. January, the Crown did not do anything. February, when the fulsome materials were filed, the Crown did not do anything. It wasn't until 2 weeks before the actual application was heard in March of 2023 that the Crown decided to spring into action.
So
and
what
again,
would you have expected them to do?
Well, exactly what they did end up doing, but too late. So 2 weeks before the application was to be heard, first the Crown emailed the trial coordinator asking if there was any blocks of dates that were earlier. And then 2 days later, it seems the Crown looked at their own matters and what was happening and what may collapse, and was able to offer 2 sets of dates. But again, this was only 2 weeks before the application was to be heard.
It was 2 weeks before the application was heard. Why 2 weeks? Because you had just filed your application.
Well,
Your application was filed on February 27, 2023. So when you say 2 weeks before the application was heard, it is because your application was served 2 weeks before the date of hearing.
Well, they didn't spring into action when we filed the application February 27th. They waited until the actual day they filed their own materials. An hour later, they decided to email the trial coordinator to actually do something.
In Jordan, I think a majority of this court in Jordan said that it's up to both the accused and the Crown to be proactive. Now, you say that the Crown was not proactive, but you were not proactive either.
I recognize that Jordan was a call to all justice system participants to work together and address delay. But again, this application was still filed in terms of the notice of application 7 months before the trial dates. It wasn't dilatory. And what this is also ignoring is that the Crown has a constitutional obligation to bring an accused to trial within a reasonable time, independent of whatever the defense says or does. I'm not suggesting that defense can sit idly by and then try to use Section 11B as a sword.
No, because we said complacency was no more acceptable in Canada. So.
But what we are proposing here and advocating for is there needs to be a proactive movement from the Crown to actually do something in this case. When they were told that 11B application would be brought, and I realized that it wasn't filed within the timelines, but when it was filed or whether it was filed shouldn't have been the impetus for the Crown to actually take action. Because
Would it have been fair, just not to follow on the Chief's comment, if you'll allow me?
Yes, go ahead.
Wouldn't it be fair to apportion some of the delay between May 2023 and October 2023 between the Crown and the defense? I mean, late defense filing, delayed by the Crown in seeking the earlier dates, shouldn't it be apportioned? Wouldn't that be fairer?
Well, don't think that that would be fair, because I don't think we should take into consideration when the application was filed in terms of the reasonableness of the delay. The trial dates have been set. Those dates were set for October 2nd, 3rd, and 4th, 2023. And those dates were set back in July of 2022. I don't think that it's above the ceiling. That shouldn't be apportioned towards the defense delay. That's the inability of the court to provide dates within the ceiling and then the schedules of counsel. And in our submission, the application judge correctly decided that only the 1 month of delay, according to the unavailability of the respondent's counsel in September, should have been deducted.
Can I bring you back to the discussion about the timeliness of the Crown's actions to find alternative dates and so on? I'm just trying to situate this in the legal framework. Where does it fit in the analysis? And if I've understood correctly, or let me ask you, are you using this as part of the exceptional circumstances framework, which requires both that it either be unforeseeable or unavoidable, the delay, and that the Crown Counsel cannot reasonably remedy the delay, can't reasonably remedy that delay with reasonable steps?
Yes.
Is it in that context that you're discussing it?
Yes, Justice Karakatsanis. That is exactly my comments in terms of the facts of this case and the action by the Crown are in response to the exceptional circumstances framework, and also the analysis that's being put forth by the appellant in terms of the inactions or actions of the defense. And I'm simply indicating that that switches the burden in terms of showing what is reasonable and available steps. The steps are on the Crown to take in order to remedy and address potential delay issues.
It's interesting because when delay is, as a matter of fact, caused by the defense, you're suggesting that you don't actually say, well, that's defense delay. It's what has the Crown done in response to it? That's the only consideration which you're asking us to have regard to. So that whatever the defense does, it's sort of like it doesn't count. The only thing that counts is how fast on their feet is the Crown. Can they tap dance? Can they, do the cakewalk backwards? Can they adjust? Can they, somehow get themselves out of the circumstances that factually arise because the Crown isn't available, because the Crown delivers things after deadlines? It's like it's always their fault. I never did nothing, it seems to be your position. Or whatever I did, it doesn't matter. It's always, how did they respond to it? Did they respond to it in a sufficiently adept and almost gymnastic way?
Well, Justice Rowe, in terms of what the Crown needs to do, as I said to Justice Karakatsanis, this is in response to the Crown's burden to show exceptional circumstances here. It's the Crown's burden, once it reaches the ceiling, that they have to show that they're either discrete exceptional circumstances or complexity to justify going above that ceiling. And if the appellant is now saying that the actions or inactions of the accused in terms of filing prompt 11B applications or promptly bringing a severance application inform their response, the respondent's answer to that is, well, we did do things and the Crown still took no action, so they cannot show exceptional circumstances in this case.
But can we just start from the beginning, because that's important to me, and then I do have a question, which is that at the very first, in July 6, 2022, the trial date was already outside the Jordan requirements. So the Crown knows they're in a charter danger zone, and you say you're bringing an 11B application. That, to me, is a very significant fact of this case. Not all cases will be like that. And some cases, you might in fact need an application to understand what it is that the defense is looking for. But in this particular case, it's clear on the face of the trial that it's outside. So I get that. But the application that you eventually filed is not in the materials, so we couldn't take a look at it. And so what you're saying, as I understand it, is that it requires the accumulation of multiple transcripts and securing of funding, some of which may have taken some time. But what was in the actual application? Because theoretically, the Crown makes a good point. They might need to know. I don't think on the facts of this case it's as strong an argument, but what was in fact in your application?
So, Justice Martin, I can actually say that the application, are you talking about the notice of application itself,
No,
or the actual
the actual
factum?
application, because look, everybody is going to want you to have met the 120-day timeline, right? Because the case management judge set that out and want that to be respected. But we're trying to assess what's the reasonableness allocation here, and so I guess I would have liked to have seen the application itself, but it's not on the record.
It is, Justice Martin. It's at
Is
tab
it?
9 of the appellant's record that was filed, not the condensed book,
Okay.
but the actual record.
Okay.
And it starts at page 50 of the appellant's record. And it's named, in terms of the bookmarks, 11B application record. And that outlines
Okay, thank you.
the factums, and then as well as the transcripts of all previous appearances up to July 6th of 2022. And just speaking to Justice Martin's point about that, the fact that the initial dates were already outside the ceiling, and that should have been a clue, I just would like to remark that in this honorable court, almost a decade ago, set a ceiling for a reason, because that denotes the limit of tolerable delay that we have in a case. In the Ontario Court of Justice, it's 18 months. And we need to know the bounds of those limits in order to be able to take action. And in this case, as Justice Martin correctly indicated, we already know at the first appearance that delay is an issue because it was already several months above the ceiling. And the appellant may say, well, that was ultimately deducted. 3 months were ultimately deducted for COVID delay. But at that point, the Crown could not know what deductions would be made for COVID-19 at that point. And in our submission, it's actually even more incumbent on the Crown in that situation, in light of the COVID-19 pandemic, to be proactive and not let cases languish in the system.
I expect a lot of cases were in that situation during the pandemic, particularly in the provincial court, were they not?
So that, according to the application judge's reasons on why he ultimately deducted the COVID-19 delay, he took his own experience as a judge in that jurisdiction and found that there were other cases that were seeing the same issues. But again, that also says to the Crown that we need to be more proactive in addressing this backlog. And again, the Crown had tools in this case, tools that they eventually utilized that they could have utilized a lot sooner.
What do we make of the issue that as I understand it, the discrete exceptional circumstances argument wasn't advanced at first instance? You read the trial judgment, and that's not what the reasons are about. Obviously, a lot of it's the code of COVID and the snake and so on. But what do we make of that? As I understand it, it was only raised on appeal and then not addressed by the Court of Appeal. So what do you say about that?
Well, Justice Jamal, Actually, at the original application, the Crown conceded that there were no exceptional circumstances in this case. I recognize according to the case law, the Crown was entitled to raise that argument on appeal. I don't think that it's necessarily fair because we don't get the opportunity for the application judge. As this honorable court has found, application judges are best suited to decide these sorts of applications. And it's just unfortunate that he did not have the opportunity to be able to address this exceptional circumstances issue at the time the application was heard.
So I'm sorry, I'm just coming back to what's at tab 9. So this is, I don't know, understand the Ontario procedure, obviously. I thought this was the factum that went in, kind of as your basis for argument. But this is the actual application, because in some jurisdictions, you just send in a form, you give notice, then you apply by giving a short application, and then when it comes time to take the application, you submit your materials. So is what's under tab 9, is that the application that was required in the 120 days?
Yes, so Justice Martin, this is the actual factum, the fulsome application, but what is only required in the Ontario Court of Justice is a Form 1 notice of application.
Okay.
That is not part of the record, unfortunately.
Okay, that's exactly what my question was. I haven't seen the actual Form 1 application. When you submit your Form 1 application, do you have to also submit what I call the factum under 9?
No, you do not need to submit a factum. Essentially, the way the form works is that you have to outline the relief that is being sought, the factual basis for the relief that's being sought, and explain why there is a breach under Section 11B.
All right.
So looking at the application, I don't see anywhere in there where you talk about these issues in response to a question about what caused the delay, legal aid, certificates, etc. So I'm just wondering, was that a factor in this case or not? Because you talk about it, but it's not in the application.
So Justice Obonsawin, in terms of the delay with respect to...
Your filing in the 120 days.
I'm sorry, I don't quite understand the question.
So I looked under the tab 9 in the record of the actual application you submitted. One of my colleagues asked you a question about the application and what led to you passing the 120 days. And you gave a whole list of answers, including, well, it could be related to legal aid certificates and other things. When I look at the application, I see none of that information in there that would have informed the trial judge why exactly you had missed the 120 days in your filing.
So, Justice Obonsawin, that's not required in an 11B application. Again,
I do understand that, but I'm just asking why it wasn't done in this case. Is it just because it's not required?
Yes, it wasn't required, and quite frankly, we did not think that it was an issue that was going to be litigated in terms of when the defense filed, because again, this is about the fact that the trial dates were above the ceiling, not what defense actions were taken in order to try to remedy that.
Purpose of the case management judge. So you know at the first hearing, July 6th, first appearance 2022, that we are already outside or above the ceiling. The judge says, the case management judge, you have until November 3rd, 2022 to file any Section 11B application. So if you say, oh, does not matter, you said it's a red herring. What is the purpose of a case management judge telling the parties, if you have a complaint to present about that, you have until November 3rd, 2022. And I'm asking my question in asking you to keep in mind what we said in Jordan and the Chief Justice referred to that before. Every actor, every participant in the system, they have the duty to make sure that efficiency will be achieved in the criminal justice system.
Again, I do appreciate that the respondent was late in filing that application and did not follow that direction. But again, the same judge did not think that that was of any moment.
It was one of his errors.
Well, that is a point well taken, Justice Cote. But it doesn't, again, the filing of the application wouldn't have made any difference in this case. Because if the appellant is saying, well, the respondent should have taken X, Y, Z step, and they didn't, and that's caused a cascading effect where we couldn't remedy the delay, that wasn't made out on the facts of this case.
But the Crown is saying that it was reasonable for them to assume that given the fact that the delay was not respected and the application was not filed, that it was reasonable for them to assume, given the context at the time, that your client was not so dissatisfied with the date.
Well, Justice Cote, what that would mean then is that the Crown would only have to have waited until November of 2022 to actually do something about the delay. When the delay was apparent on its face between the trial dates being above the ceiling, the first dates offered being above the ceiling, and a few weeks later, a declaration that the application would be brought, then that's several months where the Crown could have actually jumped into action. So what our submission is, when this application was filed, doesn't actually mean anything because those prioritization efforts could have been done back in July, August, September 2022, and they may have been meaningful then, but by the time that they happened, even after our application materials were filed, they didn't take action until 2 weeks before the hearing was actually going to take place.
There is perhaps another concern. Tab 4 of the appellant's record denotes or records 13 different court appearances between the laying of the information and the July 6, 2022 court appearance. And I read that as a court appearance because it talks about adjournment date. And it says the first one goes to 24th of December, then we have an appearance on the 24th of December to December 29th, to January 12th, to January 19th, to February. We go on and on. Now, it doesn't appear that there were any transcripts of those particular appearances. So we do have a lengthy period of time with 13 court appearances and no explanation for why it took so long to get the trial date. Now, I'm not necessarily visiting it on you. I'm just making this comment that earlier this morning we were wondering about that period. We know that that period actually was filled. One of the concerns I had was there may have been a warrant, for example, issued, and we have a non-appearance and then an accused who's arrested and then returned, and we then start the process. But it does not appear that that was the case. There were just any number of appearances here. Were you aware of that?
So, Justice Moreau, the transcripts of all the appearances are actually at tab, as part of the original application record, at tab 9 of the appellant's record, and then also Part 5 of the appellant's record also includes the transcripts from the court appearances as well.
Enlighten us on what came about. Do we know what the issues were that delayed this trial date being set?
So there's a few issues that delayed it, Justice Moreau. First of all, this was originally a 4 co-accused matter.
Right.
Ultimately, by the July 6, 2002 trial scheduling appearance, 2 of those co-accused were going to resolve in a different fashion. It was only 2 that were going to go to trial. We had to wait to have disclosure provided to the respondent and to be able to review it. And it wasn't until February and March that the disclosure was sufficient enough to actually proceed to a Crown pretrial. That happened in March. Then there had to be a judicial pretrial with all of the parties. That eventually was scheduled for June. And then from June, we were able to get the trial scheduling appearance in July.
Thank you.
Excuse me, I want to go back and ask you, you only had to file a Form 1 to get the Crown's notice, all right? And you did it outside the 120 days. You could have actually done that anytime, even in July of 2022. Just file that notice and say, we're saying it's this, and then submit the materials later. So if we're concerned about that, can you do part of your analysis on the basis that from the deadline, whether it's November 6th or November 3rd, to the time that the application is filed in February, what happens if we say that was unreasonable and attribute it to the defense?
So again, it's our...
I understand. But if we're minded, if we analyze it that way, how does it affect your overall submissions?
Well, again, I think it does not recognize that it's the Crown's constitutional obligation to bring someone to trial within a reasonable time. And again, I recognize that defense also needs to take steps that we did take. And I think that if we were to apportion delay in that way, I think that that would be an unfair and unreasonable apportionment due to the fact that those filing an application, even if it was just a notice of application earlier, would not have made a difference in this case in any event, based on the fact that once we did actually file the notice of appearance, the Crown did nothing, and that was in January. It wasn't until a month and a half later that prioritization efforts were made, and that's something that exactly the application judge in this case found, that if those prioritization efforts had been made back in the summer of 2022 when they were first put on notice, then maybe something could have been different here. And I think on that reading of the facts, if the Crown had been proactive, then maybe they would be able to satisfy the exceptional circumstances. Of course, the Crown doesn't have to ultimately be successful, but they have to take reasonable available steps in order to do that. And unfortunately, it was too late in this case.
The fundamental issue really here is about discrete exceptional circumstance. It wasn't your fault that your co-accused counsel was unavailable. It wasn't the Crown's fault that they were unavailable. So I guess in terms of looking at this, to avoid a rule that provides that the co-accused counsel schedule can hold the system hostage effectively, because it does seem unreasonable when you look at it from that perspective, and also avoiding a rule that effectively provides that where there are a joint trial, that you've got to be even faster than the regular Jordan schedule. Those both seem to be, otherwise you're going to be out of luck if something happens that's unforeseen in terms of co-accused counsel's unavailability. So how do you navigate those concerns? The fact that it wasn't your fault, it wasn't the Crown's fault, somebody else, a third party, and also that the rule that you'd be advocating would lead to a case having to be brought even faster to have some slack for co-accused counsel's unavailability.
Well, I think, again, in terms of the Crown's duty to provide an accused a trial within a reasonable time, perhaps one of the tools that the Crown has in order to do that is to resort to prompt case management, resort to prompt case planning, be able to provide disclosure sooner, to be able and recognize that within co-accused prosecutions there are inherent delays, so there needs to be something more at the front end to get that out, and that could potentially alleviate any scheduling difficulties that happen because the trial date would be set sooner.
I guess one other tool in the Crown's box, as I mentioned earlier, the issue of stacking is obviously something that's done, in, I would suspect, in every jurisdiction. But one of the advantages of it is that if you do get into trouble and you have a trial date set and you have two cases that are now set for trial in the same time frame, the Crown at least has the ability to assess which one goes ahead, because in this case, as we know, it involves weapons, firearms. And it may be joined or be stacked against a charge that may be a summary conviction offense. It gives the Crown that opportunity, which is not like a severance last resort, but it is somewhat last resort to decide whether it sacrifices one case in order to maintain a prosecution in a more serious case.
Well, Justice Moreau, I do agree with that in terms of that is one of the tools that the Crown has in their toolbox. And I think that's what the issue here is that the Crown does need to be proactive at the front end, and then also as soon as delay becomes an issue in terms of saying, well, what are the issues at play in these cases? Can I streamline the cases? Can we prioritize in other ways? Which case is ultimately more important? And do a cost-benefit analysis. Now, moving on to my submissions. In terms of the...
May I just understand your submission, which is you're saying that the trial judge found as a fact that your late filing was not a problem? Is that basically your argument? And that is a fact that we have to take because there's no argument that there was a palpable and overriding error in that fact? Is that the gravamen of what you're saying? Is that counsel for the Crown has said it would be a factual matter what the import of late filing might be in a particular case? And you're saying the trial judge determined what the import of that was and we're not to touch it?
Yes, that is, Justice Martin. Now, the appellant argues that, as we all know, the co-accused delay should be looked at through the lens of exceptional circumstances. And again, that's whether they are reasonably unforeseen or unavoidable, and whether Crown Counsel can reasonably remedy the delays stemming from those circumstances. And in terms of being reasonably unforeseen or unavoidable, it is our submission that the Crown can anticipate that there will be scheduling difficulties with